All right, so thank you everyone for coming. Before I dive in and start on the training, this training presupposes little to no prior knowledge of juvenile record sealing. I will start out with a broad overview of the different record sealing statutes and then kind of dive in about some of the very particular elements of those statutes. So as questions come up, please feel free to write them down. I'll hold off on questions until the end, and then hopefully you'll see that some of the questions that you might have as the training goes on, I have tried to anticipate them, and hopefully we'll address your questions. If not, I'm happy to get to them at the end. The other disclaimer I have is that this record sealing training was prepared for today, June 11th, 2018. As I will explain, the record sealing landscape has changed quite a lot in the last couple of years. So it's possible that 6 months down the line, some of the information in this training will no longer be, it'll be out of date. So if you're watching this and it's 2019, you're going to want to do your own legal research to make sure the information is still accurate. Okay, so how do I go on to the next slide? Okay. So starting with the objectives, the purpose of this training is really to help you as you're volunteering at one of our pro se clinics so that you're able to talk to young people, give them legal information about, the record sealing process from start to finish, so they have an idea of what to expect, give them information so they can decide whether they are eligible for record sealing, whether they should apply, what kinds of documents they should prepare in order to really make sure that a judge will find that they should get their record sealed, and give you more information so that you can really make the process clear for young people. And particularly for youth service providers, this training will also talk about some of the benefits of sealing so that you can encourage young people to get their record sealed if you feel that they would benefit from it. So in order to do that, I'm going to talk about a number of things. I'm going to start out with some of the record sealing basics, the various statutes that provide for juvenile record sealing in California. I will talk about a brief history of those reforms and why it's important to think about this historically. I will also talk about what it means to get your record sealed, so that when you're talking to a young person, you can really give them a clear picture of what that means and how it would benefit them. And we'll also talk about who is eligible under Section 781, which is the focus for today. So these are the 5 record sealing statutes that currently exist. Historically, the main statute that most people use to get their record sealed was Welfare and Institutions Code Section 781. So this is a record sealing statute that gives the court discretion to seal records related to nearly all juvenile arrests or adjudications if the court finds that the young person has been rehabilitated and meets other eligibility criteria. So, the key thing to focus on with respect to Section 781 is that the court has the discretion to do this. It's not mandatory, and it depends on whether the court finds that the petitioner has been rehabilitated to the satisfaction of the court. And so you take Section 781 and you compare that to Section 786, which is a newer form of sealing, and rather than being discretionary, Section 781 is automatic. So if the court takes certain steps, then the court is automatically required to seal a young person's record under certain circumstances. So the big exception to Section 786 is that it does not apply for 707B offenses that were committed on or after the young person's 14th birthday. So you might be asking, what is the 707B offense? I will definitely talk about that later. But for right now, just know that Section 707B offenses that were committed on or after a person's 14th birthday are treated differently for purposes of record sealing. and that Section 786, the main thing to consider is that it's automatic, it's not discretionary, but it only happens on when one of two things happen. So that's when a person is found to have successfully completed either an informal term of probation or a formal term of probation. And then the other one is when the juvenile court dismisses the delinquency petition without sustaining it. So I'll talk in more detail about what that means. Moving on, section 786.5, very similar to the previous section. This is also automatic, and this provides for record sealing whenever a person completes a program of diversion. So this is a program that a young person completes in lieu of having a delinquency petition filed, so there's no court involvement, and I'll talk more about what that looks like. Section 793, very similar to the previous two sections, also automatic, and in this case, it's when a person successfully completes deferred entry of judgment. And then finally, you have Penal Code Section 236.14. Meredith is the expert on this, so I will leave that up to her. But for right now, as way of an introduction, this is a discretionary form of sealing that the court can grant for arrests, adjudications, and convictions that were the result of the person being a victim of human trafficking. So there's a lot more to it than that. It gets pretty complicated, but that is by way of introduction. Okay, so moving on, what does it mean to complete a program of diversion under Section 786? So if you turn to the slide labeled completed program of diversion, there's a little tree of what it looks like after a young person is arrested. This is a bit of a simplified picture, but imagine after a young person is arrested, the police department broadly has two steps that they can take. They can decide to refer it to the probation department for further action, or perhaps they decide, this is really not that serious, or maybe we made a mistake and we arrested the wrong person, and they decide to close it at intake. So if they do decide to move it on to the probation department then decides, okay, we can pass this along to the district attorney to see whether this should result in prosecution, or perhaps they decide, we're going to try to divert this. This really isn't too serious. Let's give this young person a chance to show that this was just a youthful mistake. And in Contra Costa County, the main program that our county uses is called the Victim Offender Reconciliation Program, otherwise known as VORP. And so this is a nonprofit agency that provides a restorative justice conferencing model program where the young person commits community service, maybe writes a letter of apology, perhaps engages in anger management, and then if they are successful at the end of that program, then a petition isn't filed, and everyone agrees that no further action is taken against the young person. So nowadays, under Section 786.5, the probation department and police department are supposed to seal those records. And because there's no court involvement, it's not clear whether that is actually happening. But there is a means in the statute that if the young person believes that the records haven't been sealed, they can actually petition the court and ask the court to order those agencies to seal those records. So going back to Section 786, you might have asked yourself, what does it mean to have a delinquency petition dismissed without it being sustained? So again, a bit of a simplified tree of possibilities, but if we look at what happens when the DA gets the police report, they'll do an investigation, and if they decide that there isn't sufficient evidence to prove that the young person did that beyond a reasonable doubt, they can decide not to file a petition. Otherwise, they probably will file the petition, and there's a range of possibilities. So, they can decide to, the court can decide to grant informal probation, which means that the young person isn't made a ward of the court. They're not put on probation, but before those allegations are found true, the young person gets a certain amount of supervision. And if after a year or 2 years or so, the court decides this was just a mistake, this young person doesn't need formal supervision, doesn't need to be put on probation, that can be dismissed. That's not exactly what we're talking about. Then there's also deferred entry of judgment. That's when the court decides that, yes, these allegations are true, but we're going to give the young person a chance to prove that this was just a youthful mistake. And if they do well after a certain amount of time, we'll dismiss the charges as if they never happened. So that, again, is not what we're talking about for purposes of 786. 786. So what we're talking about when we say the petition is dismissed without it being sustained is when, imagine a young person goes to trial, what's called a contest, and the judge decides there isn't enough evidence to convince me that this person committed these allegations beyond a reasonable doubt, and the petition is dismissed. Or maybe the district attorney does further investigation and realizes there isn't enough evidence to go forward, so I'm going to ask the court to dismiss the petition. That's what we're talking about, and if that occurs today, then those records are supposed to be automatically sealed. So compare that to Section 781, which is very different in that we're looking at normally people who have already completed probation, their records are not sealed, and now they're having to affirmatively file a petition to the Department of Probation and go in front of the court and try to convince them that they've been rehabilitated. So this process takes more time. It is incumbent on the young person to take that affirmative step, and it's discretionary. It doesn't happen automatically, as in the case of 786 or 786.5 or Section 793. So what does it mean to have your record sealed? So, when you're looking at Section 786, I can't speak to all the different law enforcement agencies across the state, but in Contra Costa County, for example, the probation department under 786, what I've been told they'll do is they'll take the physical file, which will contain the police report, probation reports, and they'll actually put a seal over the physical file, instructing people not to open that file except under a narrow range of circumstances. And so they'll put the file back on the shelves along with all the other closed files. And so, legally, it's as if it never happened, but the file is still there. Anyone who's looking for the file will know that, the person was arrested, was put on probation, and they just won't know the specific details of the offense and how they did on probation. Compare that to what it means to seal your record under Section 781. The Contra Costa County Probation Department, in that case, will take the physical file, actually take it off the shelf, and separate it from all the other files. And not only will they do that, they'll also delete the index of it in their electronic system so that if you were to search for the young person's record, it doesn't pop up. And, for all intents and purposes, it really is like it never happened. And so that's what we mean when you seal your record under 781 and why sealing under 781 is so important. So right here I have, in most cases, it prevents most law enforcement agencies from accessing, inspecting, or utilizing sealed juvenile records. So that is, a really, really great remedy. Just note, though, that there are exceptions for 707B offenses in certain circumstances. So I will talk about that more in a minute, but just know that if you have a 707B offense that occurred on or after the person's 14th birthday, it's going to be treated like Section 786, where people will still be able to use those records against the young person in future criminal prosecutions. So that's why it's really important to focus on whether the person has a 707B offense and at what age that occurred. The other really great remedy is that it allows young people to say that they have never been arrested nor been on probation when applying to most jobs or applying for colleges, except if they have an adult record. So I have the language of the statute here because I think it is really, really powerful. So it says, quote, once the court has ordered the person's record sealed, the proceedings in this case shall be deemed never to have occurred, and the person may properly reply accordingly to any inquiry about the events, the records of which are ordered to be sealed. So that is really powerful. And I think this is important because I found that most young people are unsure about what they should say when they're applying for jobs or applying for colleges. And in many circumstances, young people can be their own worst enemy, and they will unfortunately self-disclose even when they're not required to. And so if you have a college common application for college that asks, have you ever been convicted of a crime? There's a disclaimer in there saying that if your state provides that the records are sealed or otherwise didn't happen by law, then you don't have to disclose those records. So this is one process where if you have sealing, you won't have to disclose those records. If you're applying for jobs and they ask, have you ever been convicted? Have you ever been convicted of a felony? If you have no adult conviction, the answer, regardless of what your juvenile record was, the answer to that question is no, because a juvenile adjudication is not a conviction. And if they're asking just about convictions, then you don't have to disclose a juvenile adjudication, even if your record hasn't been sealed. But what I found to be true is that having your record sealed will give young people the peace of mind knowing that a judge has already looked at it and has said, this never happened. You can, reply accordingly to any questions about that. So it's that like mental protection, knowing that, they can reply like that. And then finally, another great benefit to record sealing is that it affirmatively requires certain agencies to destroy sealed records after a certain amount of time. And so the amount of time will depend on who maintains those records. If it's a law enforcement agency, the statute requires that those sealed records be destroyed within 5 years of sealing. If it's a juvenile court that has those records, then the statute requires that those records be destroyed by the petitioner's 38th birthday. So in most cases, the court will maintain the records for a longer period of time than law enforcement agencies, except if, theoretically the person is 38 or older and their 38th birthday has already passed. But it does require those records to be destroyed after a certain amount of time. So that's great. And so you might be asking, what records can be sealed? So keep in mind that this is a state sealing provision. And so a juvenile court can order state and local public agencies to seal their records. So that will apply to local police departments who might have police reports related to an arrest, juvenile court records, including the delinquency petition, district attorney and probation records, and then also the California Department of Justice. However, this does not apply to records in other states or records maintained by federal agencies. So particularly for young people who are looking to enlist in the military or who want to apply for federal agencies or contractors that require security clearance, they should note that under a federal FBI background check, those records might pop up even if they have been sealed. So what I tell clients who are trying to enlist in the military is that they should know that it's definitely worth it to get their records sealed, but those records might still be accessible by the military. So what they should know is that they will get their record sealed. They'll ask for a waiver to join the military, but in any application process, it might be good for them to be really open and transparent and say, I have this arrest. I was adjudicated, but my records have been sealed, and that will make it more likely that they'll get a waiver granted, and it won't appear as if they're trying to hide something. And then also keep in mind that if a young person has an adult conviction, that is not something that they're going to be able to seal through the juvenile court, and the conviction, if it's a felony, could actually make them ineligible for sealing, as I will explain in a moment. So now I kind of want to take you through a brief history of recent record sealing reforms and sort of help you understand why the timing matters. So before 2015, the main avenue for sealing was under Section 781. And, as I mentioned prior, this is a process where people had to specifically petition the court for sealing, and it was a long process. A lot of young people, didn't actually take those steps. And so what the legislature saw was that probably the majority of young people didn't have their records sealed, and a lot of people who were otherwise eligible were walking around and were later impacted by these records. And so the focus of a lot of these reforms have been to try to make record sealing easier and to have it apply to a broader group of people. But as originally created, Section 781 also was had a disqualifier for anyone with a 707B offense in most cases. But